County Atlanta District Circuit is now in session. The Honorable Chief Judge York Glanville is presiding. Court will now come to order.
All right, good morning, ladies and gentlemen. Please be seated.
Good morning, ma'am.
All right, let me go ahead and take roll. We're back on record in the matter of the state of Georgia versus Cleef Adams et al. in 22 SC 183572. Mr. Stillwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen.
Good morning, sir.
All right, Mr. Williams, Mr. Steele, Mr. Adams, Mr. Pines, and Ms. Halterwinger. Good morning.
Good morning, Judge.
All right, Mr. Kendrick and Mr. Weinstein, good morning.
Good morning.
Mr. Huey and Mr. Matthews, Senior, good morning. Mr. Nichols and Mr. Harvey, good morning. Mr. Ryan and Misty Williams, good morning. All right. Mr. Smith, Mr. Uhalski, Mr. Brown, Mr. Atkins, and Ms. Hilton, good morning, councils. All right. Okay, so to pick up from where we left off yesterday, Mr. Adams, I have your proposed redactions. I mentioned yesterday, I sent, you were kind enough to send them to Ms. Weaver as well. We marked them as the next court exhibit in order, so we can work off of that. So the first one you have is page 413, line 17 to page 416, line 11. And it apparently is a conversation about a gun, about D buying a gun, whether YT bought the gun from D, and your objection is relevance and hearsay, among other things.
Yes, sir. And with the court's permission, I have had a chance to speak with Ms. Hilton on this morning. Perhaps whether she unfortunately reviewed what I sent her the other day.
Okay.
There are a number of these. I think I have a total of 28 specific ones that I've identified, and there are a number of them, probably the majority that we agreed.
Okay.
Will be redacted, and as we get to them, I'll make that notation on the record.
That's fine, sir.
So the court is correct. The first one that I have, may I keep my seat, by the way?
Yes, you may, sir. As long as you speak in the microphone so everybody can hear you.
Yes, sir.
Okay.
The first one that I have is on page 413 of the transcript, as the court indicated, starting at line 17, going to page 416, line 11. And that is, in fact, where there's a conversation that's being had about a gun, about someone named D buying a gun. And I'm kind of synopsizing the entire conversation over those pages, and whether Mr. Williams bought the gun from D. My position, and let me say this, I'm also comfortable going with the transcript. I indicated to Ms. Hilton earlier, I don't have really much of a dispute. The transcript is for the most part accurate. If the court wants to hear the actual audio and video to compare it to the transcript, I know the court will let us know that. But my position is that those sections contain testimony or statements that are not relevant. They can contain some hearsay, and they contain statements from the witness that is simply his opinion. And for all of those three reasons, they should not be admitted.
All right, sir. Ms. Hilton, what's the state's response as to those particular line and should say page and line references?
Yes, Your Honor. While I do believe the court should hear the portions of this particular section, Your Honor, and it will begin on page 413 at 411-14.
411-14
Yes, Your Honor.
through
413-35.
Okay, what's the state's position? I'll decide whether I need to hear it or not, but.
Your Honor, we believe that Mr. Coleman is talking to Dennis from not rumors, but from his personal knowledge about the fact that Quindarius Zachary is purchasing guns on behalf of members of YSL. Quindarius Zachary is an unindicted co-conspirator, part of the state's theory in a number of instances that Mr. Zachary was a straw purchaser. for a number of guns that were recovered by, YSL members, specifically the one gun that Mr. Copeland has in his possession. Matter of fact, the reason for the arrest that brought him into this interview was a gun that Mr. Quindarius Zachary purchased on his behalf. This section talks about where Mr. Zachary purchased those weapons from, and we believe that that is relevant, before the jury again going to the overall gang conspiracy in this case. It's not hearsay, it is what Mr. Copeland knows.
And so if I can just respond
Yes, sir.
briefly, and
But I would say, would like the work to be played prior to this, and we can hear the concentration, because while there is a transcript, there are some things that are indiscernible that I think the court will need to listen to and hear, and not just solely rely on the transcript.
I'm fine with doing that, and then perhaps I'll hold my my commentary until after you've heard it.
Okay, all right, let's play it, please. 411, 14 to 4, 1335. All right.
Leave him out with the gun he got caught with. You said his motherfucker gun. Why he wouldn't come claim it? But that's his big homie.
So I know too why he ain't come claim. I thought it was in his name.
Who name?
I thought it was 2 guns.
That gun ain't in nobody. It's in somebody. It's in somebody's name, but it ain't in his name.
Yeah, I just thought it was.
Right.
Yeah, he had it everywhere. So he had it everywhere.
He had a drum on it. He had a drum on it.
Oh, wait.
On that gun. I need to let y'all board or the Mickey on the board.
He gave it.
Why? When you better go?
Like they told it. Yeah, no, man, they gonna steal it and they gonna run off and all this.
So you give it a D. So why would D give it?
Look, you got another gun in the name, AK Thor gun.
Really?
Yep.
When did he buy that?
In January.
This past January?
Yeah.
Where he buy it from?
The same pawn shop.
No, sir.
Yes, he did.
Mm-hmm.
He got the same pawn shop. He bought the AK first. To Draco.
He ain't buy it from there.
Yeah, he bought it
We
first.
cool all that. We cool all that.
He bought a Draco.
It ain't from there. It ain't from Arrowhead.
Shit, I don't know where he bought it from. He bought it at pawn shop though.
And he bought it from Doug.
No, he bought it himself, but sold it though. Yeah,
Doug.
who was jugging? He was buying and selling to him for a high price.
So what if y'all find a stolen gun? Y'all still sell it to him? You just tell him it's dirty or something?
Nah, he buying whatever. He buying stolen guns, legit guns. If I call him right now, still I got guns to get back. Man, buy everything.
Just because he got it.
And we'll pause at 4:13:35.
Mellow mushroom tastes great in our pizza joints. Or in a galaxy far away. Mellow mushroom, a high order of pizza.
So, again, Your Honor, this isn't Mr. Copeland speculating, he's saying it, and he is aware that, one, Quindarius has purchased guns, two, that he bought it from a pawn shop. Now, even when this, detective
Dennis,
Dennis kept saying, it's not from Arrowhead, he said, I don't know about Arrowhead, I know he bought it from a pawn shop. And then he further goes into say, no, he bought it from himself and sold it to Thug, we was jugging. it was Biden and selling to him at a higher price. And so this is not him speculating, this is him talking about purchasing guns. Again, both Quindarius Zachary and Mr. Copeland are members of the larger, gang, which is YSL. And the fact that they purchased guns, is part of the overarching larger gang conspiracy, in which the state is proving here. So this element, this information is one, relevant, and two, it's not hearsay and it's not speculation.
Have you already asked, Mr. Copeland already about guns and the purchase of guns on direct, in your direct, thus far?
I don't recall if I've asked him about this specifically. But again, the premise remains the same. You know, if Mr. Copeland is, as he said in court, making it all up to, he made everything up in this interview in order just to get out of jail, this isn't something that he's making. This is not something that he is making up. This is something that, the evidence will show that the detectives did get, one, they did find that Mr. Zachary had, purchased the gun that he was, found in possession of. They also got, information from Quindarius Zachary about the guns that he purchased. So this is not him making it all up. As he said in court, that everything he said, he just telling them whatever it is that he wanted to say, he's not making this information up. And so.
Oh, why would you think that it could be played before you ask the witness the foundational questions? I mean.
Because that's the same reason, it's not prior to, again, Your Honor, the premise, the reason why this video can come in.
But I'm only gonna let you go so far, okay? I mean, I think you gotta ask some questions in regard to that. I mean, and if they haven't been asked, I'm not saying you can't ask, play it. If you haven't asked them already about this, there's some foundation that needs to be played.
But we can impeach in multiple different ways. The one way is impeachment by contradiction. Another way is impeachment by contradiction.
Okay. All right, I'm not inclined to let you impeach him by contradiction at this point because because he hasn't testified about anything about any guns or anything like that, and you haven't asked him anything about any guns, which you just said. So if you had asked him about guns and then he coupled with the potential not being truthful, you could probably at that point in time the foundation would probably be satisfied. I agree with you. You can impeach in many ways, but I think your foundation is lacking at this point. I'm just saying, if you're going to ask him that you still got him on direct. You can ask him those questions, and then if he denies it or whatever else, then you may be able to get into some of this. So I'm going to exclude it at this point in time, Mr. Adams.
All right, thank you, Judge. No argument on that then.
Okay.
The next one, Judge, page 419, line 10 through line 11. It's a line where this is the detective talking, suggesting that Mr. William and them is going to find out something about Copeland and, quote, knock your head off. He's talking to Copeland at that point. We've agreed, I've spoken to Ms. Hilton, we've agreed that that should be redacted.
Okay.
And I'll rely on Ms. Hilton to give us the time stamp on the video.
Let's see if we can get that. Ms. Hilton, madam?
4/16/11.
Okay.
4/16/17.
4/16/11 to 4/16/17.
Yes, Your Honor.
Okay. All right. Continuing on.
Sure.
Go ahead.
The third one, Judge, is contained at page, it's pretty expansive, page 421, line 16, goes to page 428, line, I have 16. We've agreed that it should go to 25. So that's going to be 421, line 16 to 428, line 25. That is a conversation, an extended conversation about someone named Kente and about that person having people killed, about Kente and his brother robbing and killing other people. There are numerous references to things said by unnamed individuals, references to persons potentially paying Mr. Copeland to kill someone, references to the relationship between some individuals and Mr. Williams, and assumptions of conversations that would have taken place between various individuals outside of the presence of the witness, Mr. Copeland. We have agreed in my conversation with Ms. Hilton that should be redacted.
Okay.
And as before, I've given the page and line numbers. If Ms. Hilton will be kind enough to give us the timestamp, please.
It'll be 4/18/36 through 4/25/30.
4/18/36.
4/18/36 through 4/25/32.
Okay.
32 or 32?
32. All right. Next, sir.
Yes, sir. The next one we've not agreed on. This is on page 430, line 19 to page 431, line 17. And so in that one, and again, if I can keep my seat, I'll go ahead and
Yes, sir.
I'll read the relevant
That's
parts. There's a male speaker, and essentially it's a conversation about how Mr. Copeland got to know Mr. Williams, and what is said during that part of the transcript, starting at line 17. The male speaker asks, "So how you hook up with Thug and them?" And Mr. Copeland goes on to say, "I had what I had. He wanted some weed. He wanted, I think it says indiscernible. I think it says a zip of gas." Mr. Copeland goes on to say, "And tick, like he pulls and rolling through, he'd come and get weed for him. Like I get weed for my brother. You feel me? Like he got the weed for $200. It cost $250 at the time." Mr. Copeland goes on to say, we took back up there. When we took it up there, Thug gave me the money for the weed. And then he gave me some money to put in my pocket. Gave Tick some money to put in his pocket. You know what I mean? And then I got around I just blended in and then started kicking with him. And when I started kicking with him and stuff, I think we were shooting pool. We got finished shooting pool and we left. And then out of the blue, he just called and asked for like we knew people that sell lean. You know what I mean? He started calling. He wanted different stuff. And I just knew the people who got Percocet and stuff like that, I used to just go take it to him. Okay, so that's the relevant part. I believe that is, number one, not relevant. And I want to kind of piggyback on something that Madam Prosecutor said earlier. When we were talking about one of the other statements, she said, well, that's evidence of, straw purchase of a gun. My point is, we've got an indictment. We've got an allegation of a conspiracy. And, we can't keep adding to the conspiracy by saying, well, there's something in the transcript or conversation that talks about, him buying Percocet or him buying weed. And so that's part and parcel of the overall conspiracy. It's simply not. There are some things that are just not relevant. I don't believe that, whether or not Mr. Copeland observed Mr. Williams, whether it's true or not, buying or smoking marijuana or buying or ingesting lean or Percocet, that's relevant to any issue in the case. It's certainly not relevant to anything that's charged. No specific indicted offenses, no acts of the conspiracy. So I think it's irrelevant. And I also think it goes to character. I think it's a comment upon Mr. Williams's character to insert that in the trial. It is certainly more prejudicial than probative. It's not probative of anything, quite frankly. No issue that's before the court or before the jury in this case. And so I would ask that be kept out. I simply don't think that it's relevant.
Okay.
And I'm sorry, let me just add to that before Ms. Hilton responds. I did want to address this whole issue because we keep coming back to it. That Mr. Copeland, who is on direct currently, one of the things he said is something to the effect of, I made that up. I made this stuff up. Well, that's not really carte blanche to impeach him with everything that's in his statement. We've already objected on behalf of Mr. Williams, and I think everyone else has, to the recording being played at all. But I just want to point out that she doesn't if they're attempting to impeach him, you got to kind of pick and choose what you're impeaching him for. And you don't just get carte blanche because at one point he either says, I made that up, because he also said, yeah, I probably said that. You know, you don't get to say we're going to impeach him by just playing everything, and every single thing in his statement is relevant and comes in and is not subject to any other objection. So that's my position on that.
All right. Ms. Hilton?
Thank you. First, I do want to address the impeachment issue, Your Honor, because the idea that we have to now impeach him line by line, I believe that the courts have held that we don't have to impeach him line by line, especially when he's telling the court, telling his jury.
I think we covered that already. I mean, we covered.
I do want to cite the court to a case, which is Skyner's v. States.
What is it?
318 Georgia.
What is it, madam? What's the name of the case? 318 Georgia? You said
318 Georgia, 855.
Okay, and what's the name of the case?
Sconyers, SCONYERS v. State.
Okay.
And that's an April 2024 case, Your Honor.
All right.
And here it says, and again, this is focusing on prior inconsistent statements, but I think that it's instructive. In Division 3, near Head Note 8, it says prior inconsistent statements that meet the requirements of Rule 613B are not hearsay if the declarant testifies at trial and is subject to cross-examination. The failure of a witness to remember making a statement, like the witness's flat denial of the statement, may provide the foundation for calling another witness to prove the statement was made. Here, Finch's denials and alleged lack of memory of her prior statements and their contents were a sufficient foundation to allow other witnesses to testify about the content of those statements. That is the argument and the hitting. And it goes on to cite several cases where it cites Murdoch. It says, see Nelms 313 Georgia at 788. See Bridgewater v. State, which the state addressed yesterday, which they cite or quote from Bridgewater. One witness's unambiguous denial that he had ever spoken with a second witness, as well as his assertion that he did not recall ever speaking with him, obviated the need for the prosecutor to ask the first witness about specific statements he made to the second witness and provide a sufficient foundation for the state to present extrinsic evidence of such statements. Also citing Murdoch, which was 299 Georgia 177, a witness's prior inconsistent statements about a shooting was properly omitted under Rule 613B after she testified that she could not recall the details of the shooting itself or the content of her statement.
Okay, and stop right there, just if I can hijack you just a second. I don't have any issue with anything you said so far, and I think that you and Mr. Adams coexist in that space. However, the challenge you have is you've got to still ask the question about that area, and then I think it picks up from there. I'm not going to allow you to play it until you lay a little more foundations for that reason. I'm not saying you can't play it, but you still have to give that witness an opportunity to be heard on that particular thing, asking about the gun, asking about that. So I think that what Mr. Adams is telling you and the court, the court kind of has some concern. That's why I asked you yesterday, was it discussed on direct? And you said, well, I'm going to check and see if it's discussed on direct. That's the predicate. So
if I could finish reading the next portion of Sconyers, I think that addresses the court's issue. Sconyers complains of the state's failure to confront Finch with the specific extrinsic evidence of her alleged prior inconsistent statement.
Okay, but you still have to ask him about the topic area.
So I want to get to the last portion, but
Okay.
as Bridgewater and Murdoch indicate, Finch's failure to recall making any statement at all about fighting, abuse, or anything like that, as well as her denial of the mall incident, and Sconyers arguing with Lincoln relieved the prosecutor of the need to ask about specific statements.
Okay.
So that is where we're focused at. The fact that he says, I made it all up, relieves the state from having to go line by line and asking about specific statements.
I don't have any issue with that. I don't. But I still think you guys, it's not like you have to give the witness an opportunity to confirm or deny. I'm not saying that. But I think as a matter of, you got to orient the witness and tell him and ask him questions about the gun. You can't impeach him on a gun when you haven't even asked him anything about that. Yeah, you haven't, just based on, well, I don't remember. He hasn't even said, I don't remember anything about it. So, I mean, I think you need to introduce the topic. And then if he says, I don't remember, I don't recall, then you can do that. That's why I'm saying there's foundation and predicate. I don't disagree with the case law that you cited in Sconyers and, but that's why I asked you has he testified as to that already? If he's testified about that and his memory's kind of, I don't know, I don't recall. Yeah, you can impeach him by prior contradiction or any other means that you think is appropriate under the circumstance. So I just want to make that clear, okay?
Thank
All
you,
right.
thank you,
Okay.
Ryan.
All
So
right.
as it relates to this particular portion of the interview, Mr. Copeland, I believe in court, when asked how did he meet Mr. Williams, said, I met him at the studio. I was kind of like a fan. What this portion of what Mr. Copeland tells the detectives back in 2015 is that this relationship kind of grew. It grew from possibly him being the person who facilitated giving him drugs to a more developed relationship, which was not just a fan. We have pictures of Mr. Copeland and Mr. Williams at each other's homes, or it looks like at their homes or respective places where they live. We have Mr. Copeland and Mr. Williams on tour together. And this evidence about the development of their relationship is relevant as far as
But haven't you gotten testimony about that already from the witness?
No, because he made it seem as though it wasn't a very close relationship. What he said is, I met Mr. Williams at the studio, and I was a fan of his.
Okay, well, how do you justify?
Development.
I'm sorry, hijack again. How do you justify then talking about him being purportedly Mr. Williams' go-between to acquire, illicit drugs?
So, Your Honor, again, we have charged in this indictment the fact that the members of YSL possess and sell and distribute narcotics. So this talks about that relationship. So this is relevant. This is already in the indictment. This is in the preamble of our indictment, Your Honor. Additionally, Your Honor, citing to two cases, Anderson v. State, 337 Georgia App 739, which is a 2016 case, as well as Moore v. State, which is 295 Georgia 709, which is a 2014 case, Your Honor.
Okay.
In both of those cases, it talks about relevant evidence as well as that evidence which incidentally places an individual's character into evidence. Your Honor, here in this case, there has already been testimony of Mr. Williams being stopped in a car with drugs. So this information with Percocet in 2017, I believe he was also stopped with marijuana inside that same vehicle. So this information about Copeland talking about Mr. Williams and how he met him is not anything that is more substantially outweighed by its prejudicial effect, because there's already evidence before this jury about Mr. Williams being stopped with drugs in his car, he's being stopped with guns inside the car. So the fact that Mr. Copeland is talking about this is how they met is not substantially prejudicial, and it is relevant to talk about the development of their relationship from being, whether it was his supplier of drugs, to a more developed friendship, which is more than what the witness indicated on the stand. And furthermore, Your Honor, I believe in opening statements, Mr. Steele, when talking about the relationship of Copeland and Mr. Williams, tried to distance Mr. Copeland from Mr. Williams. And I believe in opening statement, Mr. Steele tried to assert that Copeland was more friends with Demekion Garlington, in which they are friends, but really tried to distance what Mr. Copeland's relationship was with Mr. Williams. So I believe that the jury understanding the development of their relationship is important to assess whether or not they find what Mr. Copeland is saying in his 2015 interview credible.
So Judge,
And I'm sorry.
I'm sorry.
And I just wanted to cite in Anderson v. State in Division 1, it states that it is well-established evidence that is relevant to an issue in the case is not rendered inadmissible simply because it incidentally puts the defendant's character at issue. And it cites to Jones v. State. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And it cites to 24-4-401. And while relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, exclusion is an extraordinary remedy which the court should invoke sparingly, and the balance should be struck in favor of admissibility. Furthermore, as a general rule, admission of evidence is a matter resting within the sound discretion of the trial court. And appellate courts will not disturb the exercise of that discretion absent evidence of its abuse. So, Your Honor, we believe that it is more relevant for an issue on hand. It is not more prejudicial, substantially more prejudicial than probative, because there's already evidence before this jury of Mr. Williams being in and around or associated with narcotics, Your Honor.
Are you finished? Madam, so I can let Mr. Adams respond. Ms. Hilton, you done with this response?
I may have Your Honor, after Mr. Adams.
All right, so
All right, sir.
I'll keep it brief because I think maybe we sometimes have a tendency to conflate the issue. My objection is really very, very simple. That there's statements from Mr. Copeland about them either smoking weed together or him getting some weed from Mr. Williams or some lean or some Percocet. And my position is that that is irrelevant, that it doesn't go to any issue in the case. The fact that the indictment alleges that members of what they say is a gang were selling or engaging in the sale of narcotics is separate and apart from whether or not someone's smoking weed together. Right? I mean, just keeping it that simple. But moreover, if what they say the issue, what they really want is to get at the relationship. How did Mr. Copeland get to know Mr. Williams? That's what they said the issue is. And they say that this describes it. Well, that's not totally accurate because I'll do what Ms. Hilton has done to put it into context. There's more in the transcript and in the statement that actually addresses that. If you continue to read over the next page or two in the transcript.
Starting from where?
Starting from page 431, line 19. You see Mr. Copeland saying, after a while, every time I go up there, he had me chill for a little minute and stuff. I never just go up there and then leave. He says chill or something. We carry over to the next page where Mr. Copeland says, and then after that, just started hanging with him. You know what I mean? Started putting my name in his songs and stuff, just like, oh man. Then we started hanging a lot. Skip down a bit. He started taking me places and stuff. I appreciate everything you're doing for me. Like, it ain't no problem. That's how I started hanging. You know, so there really is more in his statement that describes exactly what the state says they're looking for, how the relationship developed, what was the nature of their relationship, without us necessarily having to inject this character evidence about them smoking weed together or getting lean or getting Percocet into the trial. That's simply not a relevant issue. And so the argument, I think, that I hear the state saying, well, there's been other evidence of Mr. Williams being in possession of illegal drugs, and so this doesn't matter. Right? Well, it kind of does. That's like an argument saying, well, if someone is charged with a burglary and there's some evidence or some statements about the person committing other burglaries, that, well, we can let that in because, you know, there's already been evidence about some other burglary. Well, you know, you got to notice the defense if you intend to introduce other items or relevant similar items. You just call it similar transactions, 404B at this point. But that's my position. I'm trying to keep the issue simple. I think it's irrelevant. I think it injects his character improperly, and I think for that reason, and I also think that what they're looking for is contained in other unobjectionable portions of the statement, and so I'd ask for it to be kept out.
What about, Mr. Adams, let me answer this for me, if you wouldn't mind.
Yes, sir.
What about the issue in the preamble of the indictment where it says, you know, that members possess, let's just say it's just offered for that particular reason? What would your argument be at that point in time? Because it's up to the jury to determine whether or not it's relevant, but I mean, I'll make a threshold determination, but whether or not it goes to anything.
Right.
What would you say if I just said, well, it could be potentially admissible, if just to show possession of illegal substances by YSL members, purportedly YSL members, because they have to first make that determination, but, and then of course, you know, what it would be used for.
Sure. The preamble, you know, to the indictment is really, that's argument, right? What we get to, what they have to prove and what we have to address is what's actually alleged in the indictment. What's alleged in the conspiracy, in the RICO count, and the specific acts. And we're put on notice by way of specific acts and also by specific indictment numbers. Now, if they want to allege that Mr. Copeland and Mr. Williams smoking weed together at the studio is an act that is part of the overall conspiracy, then they allege it in there. But they haven't done that, because by that logic, really there's a lot of things that are said here by Mr. Copeland that aren't part and parcel of the indictment, but they can make the argument that, well, you know, we said something about drugs in our preamble, and so all of that comes in. And I think that's essentially their argument, which I think does not control here. But my objection is just pretty straightforward, pretty simple. I think that is irrelevant. His character should be taken out. That's all.
Your Honor.
Yes, ma'am, you certainly may.
Your Honor, the YSL organization uses criminal activities to expand their criminal networks. So the fact that Rudy started off as a drug dealer, this isn't about them smoking weed in the studio. What it was is that he was bringing him the drugs, that the fact that he started off as a drug dealer and then was able to get into the gang itself or the organization and become an associate is a parcel of the larger RICO conspiracy. He went from not just the person who supplied drugs, but he moved on to a more associate membership relationship, again, talking about all of the portions that Mr. Adams just cited. So we transitioned from you bring me my drugs to now I have embraced you into our organization. Now you are a member of our organization. Now you can take trips. Now I can give you money in the club. Now you are a part of our organization. And I think that development in and of itself is important and relevant for the jury.
Well, that's a really good argument, and that's something good for closing argument. But that's, you know, and it's fine for them to have a theory, right? But just because they interpret it as such doesn't mean that there is evidence of that. You can't say that, well, him saying that we smoke weed together in the studio is evidence of him bringing him into a gang and them engaging in conspiratorial conduct. I mean, again, the state is fine to have whatever argument they want to have, but the court's determination is whether or not this particular piece of evidence is relevant, and whether or not it impugns Mr. Williams's character by its admission. I think it does. And I think it's unnecessary.
Okay. Court had an opportunity to review the indictment in this case and also consider the arguments of counsel in regards to this particular subpart. On page 430, line 19 to 431, line 17. Ms. Hilton, what are the corresponding video, audio?
You're right, that should be from 427:07 to 428:15.
All right, thank you. The defense argues that this particular period is not relevant, making a 401 issue. It's a bad character and it's hearsay. The state responds and counters that it is relevant to show the development of Mr. Copeland's relationship with Mr. Williams. They cite for that proposition Sconyers, which has been previously cited on the record, Anderson, which is previously cited on the record, and Moore, which has been previously cited on the record. The court's had an opportunity to take a look at those cases, in particular Anderson, and the court is of the opinion that given what the state is proffering that they wish to admit it for, that I'm in concurrence with the defense that it is not relevant for that particular purpose. It shows more the individual drug use or more so than it does indicate in the preamble to the indictment that for the possession, sale, or distribution of obtaining money, weapons, or other property through acts of racketeering, including robbery, theft, and unlawful sale and distribution of drugs. This is more for this, in this particular section, the court is of the opinion that it more so talks about how Mr. Copeland and Mr. Williams started their relationship in terms of the sale, or not the sale, but the acquisition of one by Mr. Copeland to Mr. Williams. I believe that would be more prejudicial than probative under a 403 balancing test. There is other information in this particular transcript or in this particular video, which does show the relationship between the two. And I believe that is more relevant in the circumstances. It doesn't kind of put us in this character issue. Now, this is my ruling on this particular portion of the transcript. If other things come up, or if the door is opened up by any other witness, or any counsel's inquiry about this, the court will go back and take a look at that, okay? But right now, I'm gonna exclude it,
Thank you, Your Honor.
okay?
The next one, memo one.
Yes, yes, sir. Unless there's any other argument by having anybody else. Okay, go ahead, sir.
436, line 23, page 437, line 15. It's relatively short passage. That's portion of the interview where Mr. Copeland is talking about statements made by Mr. Williams' father. Talks about what the father either told him or what the father says he knows, what the father thinks about him, Mr. Copeland, talking to the police. Obviously, Mr. Williams' father is not part of the indictment. I don't believe the state's gonna allege that he is an unindicted co-conspirator. The relevant portion, if we start at line 23 of page 436, just to give the court a flavor of what we're talking about, when Mr. Copeland says, line 23, and this comes on the tail end of the detectives asking Mr. Copeland about whether anyone has an issue with him talking to the police, whether they ever asked him when he's talking to law enforcement. So Mr. Copeland starts at line 23 saying somehow Thug's daddy, he be with Kente and them a lot. And Thug's daddy told me out his own mouth, like he's connected. You know what I mean? I don't know who he's connected with, but he get all this information. He get a lot of information. You know what I mean? He said it out of his own mouth, and he like, you know what I mean? He knows what's going on. That, I'm gonna say N-word, because I've been going around that word for freely. That N-word told me he could change my identity and everything. That's what he told me before beef. Like, and when he said all that, I thought he was just talking. And when I had came to Metropolitan, what's the name? He was looking at me crazy. I mean, and then from that day on, and hearing the little story, like I've been talking to the police a lot. You feel me? When I was telling the police, I wasn't telling them about what I should have been told them. I was telling them about what people were doing to me. You feel what I'm saying? So that's where it ends. That whole portion is really what Mr. Copeland is relaying to detectives, either what he heard from, what he knows of, or things said by Mr. Williams' father. Totally irrelevant and certainly hearsay. And so, for no other reason other than that it's hearsay, or that's irrelevant, I'd ask it to be extracted or excluded.
All right, state.
I don't know what it goes to.
Okay, madam.
Your Honor, I think you need to continue to read the rest of that page, because the portion that Mr. Adams just cited is not out of context with what happens on the rest of the page, Your Honor. So if you continue on, starting at line 16, he says, I didn't want to tell them about my so-called friends at the time. But in the way he was saying, like, I talked to the police a lot, you know what I mean? Like, he knew I wasn't going to tell, but he knew I was talking to him. So I don't know how he gets his information. But when he said that, I thought he was just talking at the moment, trying to scare me up or whatever. And so I think that is the most salient line, is that we're not offering it for the truth of the matter asserted, which is whether or not Mr. Williams' father has connections in the street, whether or not Mr. Williams, that's how he gets his information. But the effect on Mr. Copeland's state of mind and the effect on him as the listener, hearing whatever it is that Mr. Williams was saying to him, that's how he interpreted whether or not people knew he was talking to the police and what he was disclosing to the police. And so I think that you have to read all page 436, beginning at line 18, in conjunction with going all the way from page 437 to line 24. So we're not offering it for the truth of the matter of whether or not Mr. Williams Sr. is connected with anyone, but the state of mind of Mr. Copeland as to why he did certain behaviors, why he was concerned about who knew if he was talking to police and what was being disclosed to the police. and again, this goes back to Mr. Copeland's fear of being found out that he had been talking to the police about the homicide of Donovan Thomas.
Well, it really doesn't go to that. You know, it's a response to a question. Right? And what the detectives are asking Mr. Copeland is whether or not anyone knew or asked him whether he was talking to law enforcement. Right?
Well, specifically Thug and Kante.
Right. Yes, if you look at line 8, I think the course of is line 18. On
Yes, sir.
436.
Yes, sir.
Have you ever been questioned by Thug or Kente or anyone else as far as you, have they ever asked you, are you talking to law enforcement? He says not Kente, but Thug. And then we pick up from what I noted. So it certainly is hearsay because Mr. Copeland is opining, he has given his opinion about whether or not, or asking whether they had asked him about talking to the police, and this is why he thinks so. He talks about what Mr. Williams' father said specifically, what he drew from that, what his opinion was of it. It's really not about the effect on Mr. Copeland, because he doesn't really talk about, well, because Mr. Williams' father said this, I did this. You know, he's really just talking about what Mr. Williams' father said and what he grasped from that, what his opinion was of it. That's not the same thing as the effect on the listener, right? That's simply his opinion. And there's nothing there to say, as a matter of fact, even if you look at the last line, state, that's line 23 on page 437. Actually, it's last 22. He says, he starts saying, I don't know how he get his information, but when he said that, I thought he was just talking at the moment, trying to just scare me up and whatever. Right? It doesn't say that he scared me. It doesn't say that, you know, I did this as a result of what that hearsay statement was. It just says what the person said and what he opines the person was thinking or trying to do. And so it is hearsay. And the truth is, it is being offered for, the state wants it in for the truth of the matter asserted. But it doesn't really go to anything. It's just his opinion.
Your Honor, but that's the key point right there. It is what Mr. Copeland thought as to why he is concerned about people finding out if he snitched or not. So whether or not, again, truth of the matter asserted is that we want the jury to believe that he's connected. I don't know or care if the jury believes if Mr. Williams is connected or not. What the state wants the jury to understand is that this conversation that he had, that Mr. Copeland had with Mr. Williams, informed what he thought about if people are going to know whether or not he told police about the crime, which is the murder of Donovan Thomas, and his concern about that. Truth of the matter asserted would mean that I want the jury to believe whether that Mr. Williams was connected, that I want the jury to believe that Mr. Williams told Mr. Copeland he could change his identity. I don't know if he can change his identity or not. That is not what the state is offering it for. That is offering it for the truth of the matter asserted, that Mr. Williams could actually go and change his identity. I don't think Mr. Williams works for FBI or any other agency that could do that. So that's not what we're offering it for, Your Honor. We're solely offering it about Mr. Copeland's, the effect that this conversation had on him and the fact that he was disclosing a murder to the police.
So, if what they wanted in for are the things they've just said, they want the jury to know that Mr. Copeland is concerned about his name being out there or him being labeled a snitch, or that he is talking to law enforcement. Then it's cumulative because they've already got that. There's already been testimony. I think the jury's already seen a portion of a statement where Mr. Copeland is talking about he doesn't want to be known as a snitch, that he didn't want any paperwork with his name on it. You know, so there's been testimony about that. You've already let that in, right? But what we're talking about here is hearsay, something that Mr. Williams' father purportedly said to Mr. Copeland. And, you know, I'd understand, I would go with them, with their argument, if the transcript continued on and Mr. Copeland said, and, you know, after he said that, I was, you know, that made me really think about whether or not, you know, I was being labeled as a snitch out here in these streets. Those are my words, obviously. I'm giving an example.
Yes, sir.
But it doesn't say that, right? So he's opining on whether or not anyone knows that he was talking to the police, and based on, and he thinks yes, based on what the hearsay statement is from Mr. Williams' father. But we've already got that. It's cumulative, and so we don't need this hearsay to add to the evidence that's already been admitted.
And Your Honor, I understand that Mr. Adams keeps saying it's hearsay. It is not. And the fact of the matter is, it's not cumulative, because the fact that, and especially in this part of the interview, he is telling a different set of detectives this information. He's actually talking to some IA detectives about information that's not going to come in at this point regarding Officer Beebe. And they're asking him and trying to understand, why are you coming forward now? What is your purpose? And he's beginning to tell them again what he's consistently said in this interview about his concern. And that is important, again, when Mr. Copeland is saying he made all this stuff up in court in 2024, everything I made up, I made it all up. They get to see that his biggest concern was being labeled a snitch. That was one of his biggest concerns in this interview.
I understand that, Ms. I do. I just don't think that this particular section drives home that point. I do agree with Mr. Adams. I think that it's cumulative, and it may be the relevance of it is because it really does not go to Mr. Copeland's fear in this particular circumstance. It doesn't. I think there are some other, or him talking about the police, or talking about speaking to the police and his concern being a snitch. I don't think it goes to that. I think he's just communicating third-party information from Mr. Williams' father. And it's not really kind of relevant for the purposes that, at least in the court's opinion, as to this particular issue. Having said that, I'm going to exclude it. But again, if somebody opens the door up as to it and lays a foundation as to it, then I may revisit my decision on that. Okay. But right now, I don't think the conversation between Copeland relating about what Mr. Williams' father told him is relevant.
Well, Your Honor, while the state will just ask for continuing objection, we understand
You
the
can
court's
have
ruling.
it.
We don't believe that it ends at 15. Then we believe that any information regarding any hearsay statements actually stops at line 8
Line 8 of what page, ma'am?
of page 437.
Okay, well, we'll anybody else want to have any other discussion about that particular edit? If not, and Ms. Hilton, if you would give us the corresponding audio visual time from 436 line 23 to page 437 line 8.
It'll probably be around 432.50
432.50?
to 433, approximately 26.
All right. Okay.
We've got a lot of agreements coming up on the next few.
Okay, but Mr. Weinstein's got that on bladder's full look. So I've just been tracking the time, and he just usually kind of, inserts himself right in there. So I'm going to preempt that, Mr. Adams. Can we take 5 minutes, please? Okay, all right. We'll be in recess. All right, thank you. Okay, all right, folks, we're gonna go probably about another 10 minutes and then we'll pick up tomorrow morning, 9:30, I anticipate 10 o'clock start time. We'll see if we can't finish up or see where we are at that point in time.
Can I suggest, then, Judge, that, we got a lot that we agree on.
Okay.
Let me put those on the record.
Sure, and that's what I was gonna hopefully suggest you all would be willing to do at this point, so that would lessen, what we need to discuss. All right, you wanna tell me which ones you
Yes, sir.
which ones you agree upon?
Okay, so, the next three that I've cited are, page 457, line 2, to page 457, line 11. The next one I've cited, and I'll give you all the time stamps, okay. The next one I've cited is page 463, line 4 to page 464, line 12. And then page 465, line 5 to page 465, line 7. The state is in agreement to having those redacted, but theirs is a little bit more expansive than mine. And so what we're actually agreeing to redact altogether is page 457, line 2, all the way to page 471, line 20. And
Well, what was the one, 470,
we start at page 457,
line 2?
and we're gonna go all the way to page 471, line 20.
All right. Is that the state's concurrence?
Yes, Your Honor.
Okay, anybody else wish to be heard about those particular edits? Tell me what time or what that roughly equates to on the audio video portion, madam?
Yes, Your Honor, so roughly it's about 5:05, sorry.
5:05:53
Okay, if
So-
go ahead.
to 5:18:37.
Okay, all right. Okay, Mr. Adams, what else do you have concurrence on?
The next one that I've got is page 476, line 3, page 477, line 23. That is very briefly a conversation about Shannon and someone named D. It makes reference to a rape allegation against this person named D. The state has agreed that that's going to be redacted. So page 476, line 3 to page 477, line 23. If Ms. Hilton give me the timestamps.
Okay, all right. Ms. Hilton,
Your Honor, it's gonna be 5:22:42
522:42,
through 5:24:31.
520, you said 524?
5:24:31.
Yes, ma'am.
Yes.
Okay, all right. Any further objection or comment? Okay.
The next one, Judge, is going to be page 478, line 12, page 478, line 17. Conversation about Bentley. My objection was hearsay relevance. The state has agreed that will be redacted.
All right.
Please, Ms. Hilton.
Yes, it's going to be, Your Honor, 5:25:01 to 5:25:21.
Okay. Any further discussion?
No,
All
Your
right, then that will be omitted. All right, Mr. Adams, next.
The next encompass, 1, 2, 3, the next 4 that I have. So
Where does it start? From which one to which
we're
one?
gonna start at page 480, line 19, and we're gonna go all the way to page 487, line 10.
Okay,
That encompasses 4 that I've listed, but we've agreed that that entire portion will be redacted.
okay.
If Mr. Hilton can give us a timestamp.
That's gonna be 5:27:26 through 5:33:45. And to be clear, that's from 480 line 19 through 487 line 24.
Instead of line 10, it's 24?
Yes, Your Honor.
Okay. Mr. Adams, are you in concurrence with that, sir?
To 487, line 24?
Yes, sir.
Yes.
Yes, I'm sorry, I was looking at the wrong one, yes.
Okay.
And Miss Hilton, the timestamp, the ending timestamp was 5:33 what?
45.
45, thank you. May I proceed, Judge?
Yes, sir, you may.
I'm gonna skip over a few to get to the other ones that we agree on.
Okay,
If we go down to where I have page 500, line 15, page 500, line 23. And that one, Mr. Copeland references text messages with D and or Shannon. We've agreed that that should
No.
be,
That's when we have a question mark on. We're gonna come back to that one.
okay, strike that. Strike that.
Okay, all
We're
right.
still talking about that.
Okay, all right.
Okay, so the next one then is actually page 503, line 15 to page 503, line 22. That involves the detective, my words, bolstering Woody's credibility, Mr. Copeland's credibility, and describes how good he is about helping out. We've agreed that that should be redacted. So that's page 503, line 15 to page 503, line 22.
Okay, stay in concurrence?
Yes, Your Honor.
All right, and what are the time, or I should say the audiovisual marks?
5:48:10
5:48:10,
through 5:48:27.
5:48:27.
Yes, Your Honor.
Okay, all right, any further discussion? All right. Mr. Adams, next.
Sir, the next one is page 504, line 10 to page 504, line, I have 6. That should
Yeah.
probably be 16.
Yeah. You do have search. It's line 15.
15. Okay, one moment, please, Judge.
Okay.
504, line 10. 504, line 15.
It's 505, line 6. Or it's 505, line 6, Mr.
Yes, that's what it should be. So it should be, yeah, there we go. So that's page 504, line 10 to page 505, line 6.
All right, is the state, okay?
And that is the detective giving an opinion about Mr. Williams, talks about D's bond hearing, about the reason the judge gave him a bond, and testimony from the bond hearing. We've agreed that that should be redacted.
Okay, is the state concurrence?
Yes, Your Honor.
And what are the video, audio time acts?
I have 5:48. $5:48. 56. They do 5:49. 39, but course indulgence for one more.
Yes, ma'am.
Okay, yeah. So 5:48:56 through 5:49:39.
All right, any further discussion? Okay, Mr. Adams, next.
So the next one is page 507, line 3 to page 508, line 8. That's a segment where the detective is talking about how people, in quotes, are waiting for Woody in jail and how he won't be safe in jail. And Woody makes a statement about the COs at Rice Street helping out Mr. Williams. We've agreed that that segment should be redacted.
All right, and what is the state in concurrence?
Yes, Your Honor.
Okay. And what are the times?
5:51:36
5:51:36,
through 5:53:04.
5:53:01,
04.
04. All right, any further discussion? If not, they will be omitted.
The next one then is page 508, line 24 to page 508, line 25. That's just a statement where Mr. Copeland opines that, quote, Birdman is the mastermind behind Young Thug. We've agreed that that should be taken out.
State and concurrence,
Yes, Your Honor. And the
Alright.
timestamp is 5:53:22,
5:53:20 what?
22
Okay,
through 5:53:25.
all right. Any further discussion? All right,
Next one is page 520, line 19 through page 520, line 24. That's Mr. Copeland giving an opinion that Mr. Williams would supposedly have tick killed. We've agreed that that should be excluded, redacted.
all right. Is it state and concurrence?
Yes, Your Honor. And the time is 6:02:38
6:02:38,
through 6:02:47.
all right.
602,
38 through 6:02:47.
thank you.
All right, what's next, Mr. Adams?
The next one is page 528, line 11 to page 530, line 2. Detective Thorpe is talking about how loyal and great Woody is and how reliable he is. We've agreed that should be redacted.
All right, state and concurrence,
Yes, Your Honor. And the time is 6:08:59 through 6:11:08.
okay, any further discussion? All right,
The last one, Judge, is page 523, line 12 to page 540, line 6. That is Mr. Copeland and his girlfriend Deshawn are having a phone conversation. That phone conversation is captured in the audio. We've agreed that that should be redacted.
state and concurrence,
Yes, Your Honor. And that'd be from 6:13:27
6:13:27,
to the end. And I think it ends at like maybe 10 minutes later, about 6:23.
okay,
And Your Honor, there's one additional section that we're going to agree to,
Which one's that? Sir?
521.
Okay, the one right above that.
Mhm.
All right,
okay, so which one are you also gonna agree?
Judge, that would be third from the bottom, page 521, line 20 to page
521, line 20,
Yes, sir, to page 521, line 23. That's where Mr. Copeland references a conversation where supposedly Yak says that Mr. Williams is going to have Tick killed. We've agreed that that should be removed as, well, my objection was confrontation, speculation, and hearsay.
And Your Honor, it actually is extended to page 522, line 5.
it goes to 522, line 5?
Yes, Your Honor.
Okay, Mr. Adams, you in concurrence?
I have 1 second.
Yeah, 522, line 5.
Okay, that's, yes, we're in agreement with that. That's fine.
Okay, all right. And what are the time?
So that should be around from 6:03:23
6:03:23?
through 6:03:44.
Okay,
I'm sorry, Ms. Hilton, I didn't hear that. One more time.
Sure, 6:03:23 through 6:03:44.
Okay, thank you.
You're welcome.
By my count, Judge, if are you ready? If the court's ready, it looks like we've got 1, 3, 4. We got 6. We got 6 more to
okay.
chapter 1.
And then there's the two that from Mr. Sharp from yesterday that we need to also kind of bring to closure.
Yes, Your Honor.
All
I
right,
think the state has I'll take a look. The state had a few that overlapped with mine. I'll take a look and be prepared to address that tomorrow. They
Yeah, I
might-
think all of the ones that the state had for this portion, I believe, are inclusive of what defense counsel asked for.
Okay.
Okay, so tomorrow, our goal would be to exhaust those two or those particular remaining sections, as well as potentially start on the phone calls. Okay?
Yes, Your Honor.
All right. Have you all identified those particular things in the phone calls similarly to the tape that you believe you can share with the defense?
So we've identified the calls. We can get something over to them with the specific portions of
This
it.
is helpful because it kind of just, it narrows the issues. So if you could do that, that would be great. And if you all have corresponding objections, it certainly helps the court in resolving those. Okay?
Yes, Your Honor.
All right. Anything else we need to cover with y'all before tomorrow? We will meet tomorrow morning, starting at 9:30 for an anticipated 10 o'clock start time. And we will we'll be in session till probably, I would say early, I'd say no later than probably about 2 o'clock or thereabouts, okay?
Okay, thank you, Your Honor.
All right, okay. Oh, Mr. Kokomo and Mr. Youssef, I didn't recognize you this morning, but good morning, gentlemen. Okay, all right, we're in recess, okay? All right, see y'all tomorrow.